It's my honor to welcome you to this conference of the Constitutional Law Center. I'm Michael McConnell. I'm the faculty director of the center, and I'm excited to hear. We were really pleased with the lineup for this conference. I wonder if it's post-COVID conference appetite, because we had a higher than usual acceptance rate, and that will produce, I think, a livelier and more interesting, even than usual conference. Thanks to all the speakers out there and to those of you who have come to attend. Our topic is text and what kind of history, because anyone who has been following the Supreme Court's constitutional jurisprudence in recent years will have noticed that there is a shift across a number of different areas of doctrine in which the court is trying to get rid of basically interest balancing and replace it with something that they often refer to as, text and history, or sometimes history and tradition. But it's not always clear what the theory is. It's not always clear exactly where this has comes from, and as our title indicates, not always clear even what kind of history we're talking about. And so the purpose of this conference is to bring together scholars who've been thinking about these issues to reflect on the use of history in modern constitutional interpretation, with the hope that maybe some non-advocacy scholarly reflection will advance our understanding and maybe even help the world a little bit. And so with that, I am going to turn this over to Bob Gordon, who is going to be moderating the first panel.
Okay, welcome everybody. We have a very distinguished lineup of speakers for this panel. Their biographies are in your materials, so there's no point doing elaborate introductions. That will just take away from substance of time. And we're going to proceed from your left to right here, beginning with, let's see, time limitations, probably 10 to 12 minutes for about each, I think. Make sure we have time for discussion. So we start with Sharif Girgis of Notre Dame Law School.
Thank you. Thank you so much, Michael, for putting together the lineup. I'm amazed by the lineup. I'm more amazed that I'm included in it, and very grateful for that. So I'm going to talk about the tradition part of history and tradition. A lot of people have observed that the court increasingly is basing its reading of the constitutional text on traditions, in particular on the post-ratification practices of other actors, of the political branches, of state officials, state courts, sometimes of ordinary people. And I want to make two main claims about that. That in a huge number of those cases, the court is relying on tradition in a way for which there's no obvious originalist-friendly rationale, and also in ways that have a very unoriginalist upshot to how you should handle the precedents based on those traditions. So no obvious originalist-friendly rationale, because it's not relying on pre-ratification traditions that might have been incorporated by the original meaning of the text, like with the Seventh Amendment jury right, which incorporates the jury right as of 1791. It's not relying on very early practices as evidence of original meaning, on the theory that the people who ratified the text wouldn't immediately turn around and violate the text. And it's not relying on traditions that reflect somebody else's resolution. It's a deliberate debate and resolution of the interpretive issues. So it's not talking about judicial precedents, which originalists have given arguments for relying on, and it's not even talking about the non-judicial analogs of judicial precedents, what James Madison and Will Bode call liquidation, which are cases where political actors have themselves expressly debated and then resolved a debate over the meaning of a constitutional text. It's relying on practices that aren't any of those things. And the upshot that I think follows from it is that if you do try to think of a good rationale for relying on those traditions, they all have the implication that constitutional law on these issues should be updated as our political traditions change. that constitutional precedent shouldn't be treated as fixed in the way that originalists would, at least by instinct, be inclined to treat it. So a couple of examples from the most recent term. The most obvious and salient ones are Dobbs on abortion and Bruen on guns, which both look well after ratification to figure out the scope or existence or non-existence of those rights. But there are less sexy rights cases. So Houston Community College versus Wilson is a case about free speech rights, which Justice Gorsuch's opinion resolves based on the practices of education boards, local education boards as late as 2020. There are plenty of non-rights cases. So in TransUnion, the court figures out what counts as a cognizable injury for standing purposes under Article 3 by looking in part to the practices of state courts as late as the 20th century. A few years before that in Chiafalo, the court, including the originalist justices, resolves the question of whether states can punish faithless presidential electors, again by looking at practice well into the 20th century. In Zivotofsky, a few years before that, the court decides the scope of Congress's ability to interfere in the president's recognition of foreign powers, again by looking at 20th century practices. In the cases about whether you can, when and whether you can have adjudication of claims outside of Article 3 courts, the court is again looking well after ratification. What I found is that this is not just a recent trend, though. When I dug into this for a paper that I've called Living Traditionalism, because it's focused on traditions that are post-ratification, that are living in that sense, it turns out that the court has relied on practices of this kind in basically cases covering every area and every era of our history under many different provisions of Article 1, Article 2, Article 3, on all 10 amendments of the Bill of Rights, except maybe the third, under the 14th Amendment. Just to pick on the rights cases, what counts as a public forum or an establishment under the First Amendment? What's the scope of the right to keep and bear arms under the Second Amendment? What counts as a seizure under the Fourth? What counts as due process or under the Fifth? Where do I get my right to testify in my own defense under the Fifth and Sixth? What are the rules for fines and executions under the Seventh and Eighth? The anti-commandeering cases under the Ninth and Tenth? And then under the Fifth and Ninth and 14th Amendments, is there a right to assisted suicide, abortion, cohabitation, sexual intimacy, parental rights, and so on, as a matter of unenumerated constitutional law? In all of those cases, the court is relying not just on practices that post-state ratification, but also on practices that, for all we know, do not reflect liquidation. Liquidation, according to Madison, and I think Bode, though he'll correct me, is supposed to be an analog to judicial precedent in the sense that it involves political actors debating a constitutional issue, reaching a resolution, and then practicing according to that resolution for a period of years. And so the idea is that just as following judicial precedent hits the sweet spot between getting the law settled and getting it right, because you're at least deferring to somebody else's effort to get it right, you can do the same with deference to liquidation. But in 50 or 60 cases that I found, the court does not show that there was any debate about the issue in question. In some cases, it tells us that nobody really adverted to the constitutional issue that it's interpreting. In a lot of cases, it's very clear that the actors were motivated by something other than their convictions about what the meaning of the Constitution was, and so on. So what rationales does it give? Well, it gives a couple different rationales. In the structural cases, when the court has explained why it's relying on these practices, it has tended to say, first, this is a matter of departmentalism, respect for the practices of the other branches, and second, some kind of Burkean or Hayekian argument about the value of tradition, the idea that these practices, if they've accumulated over time, they reflect the wisdom of these other actors about maybe implicitly about what the Constitution means, or maybe about what would be a favorable resolution of these issues, or a resolution that works. In the rights cases, the argument has been a little bit more metaphysical. It has been that practices actually make it the case that something is or isn't an unenumerated right under the Due Process Clause, for example. And it has also made a kind of democracy argument. If we're going to have unenumerated rights, it's more legitimate to base them on the people's practices. I think in some cases, there's no clear rationale where the court slides among a bunch of different rationales. I think that's true in Bruen. At some points, it sounds like it's saying the gun right is a pre-existing right, so we look at traditions even after to get a hint of what came before. Some cases, it says it's just evidence of original meaning. Neither of those rationales really supports the rule that it comes up with. In any event, this is not just a non-originalist thing or a recent originalist thing. I think Justice Scalia was a prolific author of what I'm calling living traditionalist decisions in figuring out what counts as procedural due process under Burnham versus Superior Court, in figuring out what's a public forum in a case called Burson, in figuring out when you can have adjudication outside of Article III courts in his concurrence in a case called Stern v. Marshall, and in figuring out what the scope of parental visitation rights is under Michael H. versus Gerald D. in a bunch of cases. The case on free speech rights that I mentioned from last term, in which Justice Gorsuch wrote the opinion for the court citing 2020 practices, was joined by all of the justices. The anti-commandeering cases, the federalism cases like NFIB versus Sebelius, the originalists are pointing to post-ratification practices. I think there's a possible reason for that, a set of motivations for that. One is that in a lot of these cases, the text is pretty spare. So for originalists in particular, it might feel, citing these historical practices might feel more legitimate than just citing their own policy preferences, and maybe substantively preferable to just falling back on Warren and Burger Court precedents. In other cases, citing practice might give you a way to chip away at disfavored precedents without making the full-on originalist argument that might require overruling them. So arguably, American Legion did that with the Lemon Test for Establishment Clause doctrine before Kennedy declared the Lemon Test dead. And in other cases, it might allow you to overrule one precedent without making the originalist argument that requires overruling nearby precedents, and arguably that's what the court did in Dobbs. I think at the end of the day, the overall case for relying on living tradition in these areas will probably vary case to case. Maybe in some areas it's the only thing you've got. Maybe in some areas the substance of the provision actually makes post-ratification practices a determinant of the right at issue, maybe under the Privileges or Immunities Clause, for example. But whatever the rationale and whatever the area, I think, and I tried to show in the paper, that logically you'd be committed, if you're relying on living tradition at all, you're committed to updating the precedent based on it as those traditions change. And I'll end just by illustrating that for ease of reference with the most, ease of exposition with the most salient case, Dobbs. So Dobbs, a part of it sounds originalist. It says, look, there's no right to abortion under the 14th Amendment because in 1868, when it was ratified, nobody acted like there was a right to an abortion. The dissent responds by saying, you're going to freeze us with the list of rights we had in 1868, with that logic. And in a portion of its reasoning that the dissent describes as window dressing or an argument on the alternative or just arguendo, the majority says, well, you've got us wrong. Our application of Glucksberg extends 100 years past 1868. Now, if that's really an answer to the objection that you're going to freeze us with the list of rights we had in 1868, it implies that post-ratification practices can give rise to a new right, which also entails that if the court had first gotten to the abortion issue in 1993 instead of 1973, and if by that point states had liberalized on their own on the abortion issue, there's at least some scenario in which this living traditionalist logic would suggest that there would then be a constitutional abortion right, that the court should have found a right in 1993. And if you then treat these precedents as fixed, you get the bizarre result that whether there will be a constitutional abortion right depends on an accident of history, not on how the law was in 1868 at ratification, which originalists have an argument for, not at how practices are in the rolling present as living constitutionalists have an argument for, but how practices happen to be at whatever arbitrary in-between point the court first got to the issue, 1973 or 93. I think that doesn't make sense on any particular theory of the judicial role or popular sovereignty or of any given argument for relying on living tradition. And I think something analogous is true under the structural cases, though I can go into that argument later. So one way or another, I think if you are going to use living traditionalism at all, and if it's going to be an actual hinge point of a decision, which there's a debate about in Dobbs, then you either should treat living traditionalist precedents where the practices have become obsolete. You should either treat them as superseded in the way that you would treat a precedent, a statutory precedent as superseded when the statute's been amended, or at the very least, you should say that when the political traditions have changed, that by itself is a presumptive argument for overruling the case, regardless of other stare decisis factors. So I go through a bunch of applications of that and a bunch of examples where our traditions have changed. I'll end on this one more point. Another way in which this might upset a certain kind of originalist account. If I'm right that living traditionalism, what I'm calling living traditionalism, is pervasive, and if it's so pervasive among justices of all stripes that we have to say it's widely accepted, and if it doesn't have a good originalist-friendly rationale, then it raises questions about the degree to which originalism is our law, the degree to which originalism is the positive law of interpretation of our system. So anyway, with that provocative ending, I'll say again, thank you so much, and I'm looking forward to all the panelists.
Thank you. Jonathan.
Thank you. Well, I feel on that closing note, it should be Will who's going now, though I'm sure I'll give him much to sink his teeth into as well. Thank you. It's a pleasure to be here, Michael, as always, for including me in this incredible event with such august company. So how has and how should the Supreme Court use history? I come at this as the perspective of a historian of the founding era, someone who spends a lot of time trying to understand the early Constitution in its 18th century form, spending a lot of time trying to climb inside the minds of people from the 18th century and understand how they thought about things. And that leads me to come at a lot of the same kinds of questions that preoccupy people on the court or modern lawyers, but I usually come at them from a very different angle of attack, I feel. I'm sort of moving forward in the 18th century up to the founding rather than looking backwards from the 21st. And perhaps because of that, despite asking a lot of the same questions, I'm often struck more than some other people are who ask those questions by differences between the 18th century and the present, how people thought about constitutionalism and law and related subjects, which accordingly has made me skeptical of the tacit belief that I think is often exhibited on the Supreme Court, and especially of late, that various aspects of modern legal thinking and jurisprudence can be imposed on the 18th century without distorting it, without doing violence to it, that we can ask many of the same questions, we can appeal to many of the same doctrines, we can use a lot of the same legal concepts without in some way altering that history. So when I think about the court's use of text in history, this is usually the concern that is foremost on my mind. I tend to think that the court assumes pretty strong doctrinal and conceptual continuity between past and present. Maybe people have different answers to the questions, but a lot of the questions are pretty consistent over time. And as a historian, I'm usually struck by discontinuity, not just in the answers, but also the questions themselves. So whether this is appealing to the original meaning of the constitutional text or founding era legal principles, or more recently, post-ratification practice of one kind or another that Sharif laid out with his taxonomy so well, I think too often there can be this assumption on the court that the past speaks more or less directly to the present, that the past comes prepackaged on the terms of modern law. And as a result, then, the kind of historical inquiry that the court engages in can be relatively narrow. So this is, as I see it, an issue of context, and that's what I want to briefly chat about now. Everybody agrees, originalist or not, that if you're going to engage in the exercise of deciphering the original meaning of the Constitution, you have to place it in context. Everybody agrees on that. The question is, what kind of context? How should we understand the character of the context? I think this is where the disagreement arises, and too often, to my mind, as I just hinted, when the court does this, I don't think they contextualize enough. The context is too narrow and needs to be broadened. And when that is told to them, there's usually an argument, which was just made by Justice Thomas in his Bruin opinion, that that is an oblique critique because you are misunderstanding law to be history, that lawyers ask different questions than historians. And I want to try to push back against that idea by speaking briefly on why I think the context should be broader and what I mean by that. So what do I mean? What do I mean that it needs to be broader? Well, what I mean is that if we want to understand an 18th century text like the Constitution, what we need to first understand is how people at the time thought about things that were implicated in constitutionalism. You can't just look at the phrases that make up key constitutional provisions, you have to understand the concepts and, much more importantly, the way the concepts form a conceptual framework that are implicated by the provision. The words on their own can't tell us very much. None of us could easily read anything in the Constitution unless we already brought to bear on it a set of robust assumptions about the nature of liberty and governance and Republican governance and separation of powers and even constitutionalism itself, of course. And that's no different than people in the 18th century. So it makes a huge difference if they thought differently about those things or put them in a network of concepts in different ways, which I, as a historian, think they very much did. So the basic point I want to emphasize is that I don't think we can decipher the original meaning of key constitutional provisions without attending to that broader, much broader intellectual and conceptual context. There's no way to bracket it. It's woven into the whole thing. It shapes legal questions as much as any other kinds of questions we might ask of the 18th century. If you want to know what it originally meant or what was originally laid down or how they tried to liquidate it in its early going, you have to get at that broader network of constitutional concepts. So to illustrate this very briefly with just two examples, take the concept of liberty itself. The Constitution is obviously full of a lot of rights provisions. So many litigated cases, especially from this most recent term, hinge on the meaning of these rights provisions. And as I suggested earlier, the court's analysis is usually structured by modern doctrinal categories focused on the particular word meanings found in the provisions. But if you want to read any of these, you first have to have some understanding of what liberty is itself. And if we're interested, as the court claims to be, in what these liberty provisions meant in the 18th century, we have to understand that people at the founding understood liberty often much differently than people do today. People at the founding lived before the liberal rights regime, in broad strokes, had emerged that came to define, again in broad strokes, liberty as non-interference. So according to that understanding of liberty as non-interference, to be free is to be free from the interference of an external agent, paradigmatically the state. This is a formulation that tends to see liberty and government power as inverse of one another. But for the most part in the 18th century English-speaking world, and this had been true in the English-speaking world at least going back to the English Civil War, liberty was not understood as non-interference. It was understood as self-governance. This was a very different sort of concept. To be free did not mean that people weren't interfering with you. It meant that you were not subject to an alien will. You were either subject to your own will, which made you free, or you were not, which by definition made you a political slave, because you were subject to arbitrary authority. So it wasn't about interference, how much the state or any other external agent measurably interfered with your life. It was about whether that state did or did not embody your will, which was why representation was the most important concept in 18th century constitutionalism and was the precise concept that led to the American Revolution, because if the government represented you, if it was you in a real sense, then that government could do all kinds of things and interfere with you in all sorts of ways without violating your liberty. And if the government wasn't you, even if it didn't do anything to interfere with you, it was by definition tyrannical because it had the potential to do so. So I think if you take a sort of more modern liberal rights understanding of liberty as non-interference, which emerged in different places in different times in complex ways in the 19th century, and you quietly attach them to, say, the First Amendment or the Second Amendment or the Fourth Amendment, in a great many ways you're wrenching it forward toward the present. Now, there's different ways to think about this. You can think about the history and tradition standard or certain practices attaching some of those meanings that are evolving over time. You could think of the Reconstruction Amendments entrenching a different version of liberty than existed at the founding. But at least as I can see it, that's not the kind of thing that the court has argued or has done. And in fact, for my money, when the court weighs in on this, there is not very much evidence that they've even thought seriously or even recognized what I think over half a generation of historical scholarship on 17th and 18th century liberty has underscored, that it's very different than a lot of the ways people conceptualize it more recently. Very quickly, second example, federal power itself, obviously a big issue, the scope of federal power. When people debate that today, it's usually based on a certain understanding of which enumerated powers do or do not extend to a certain point, most famously the Commerce power, but usually at the founding, when people thought about the scope of federal power, they thought it hinged on not those particular questions, but instead the right way to understand the underlying nature of the federal union. Was the United States of America a nation, a confederacy of sovereign states, or something in between? And very importantly, that was not first and foremost something that you turned to the text to figure out. The text could have leading hints, but it was a sociological and historical analysis that you needed to perform of what the United States was that told you some sense of the scope of federal power, which is part of the reason why in the early republic, the preamble to the US Constitution was used constantly in constitutional debates, or at least far more so than recently when it's not used at all. And the Commerce Clause was rarely appealed to in these questions until actual interstate Commerce Clause cases began piling up in federal courts in the 19th century. So again, it's a way in which a particular framework, a way of thinking about things, influenced how people were negotiating these things. So in conclusion, what I'm trying to suggest is that I think the court's steady failure to think in these broader contextualist terms can lead it to engage in a form of historical ventriloquism, or at least it runs the risk of that. If you take bits of historical data here and there and plug them into modern doctrinal categories and concepts, if you venture back to the founding, assuming that the founding speaks in these modern doctrines and modern concepts, if you assume that the founders speak our language of constitutionalism, you can run the risk of making them speak something very different than they were. So what I would suggest here is more reflection and humility. It's not just a matter of the court can get the history wrong. Lots of people complain about that. It's that too often the court assumes, without thinking it could be otherwise, that the history, whatever it might say, speaks directly to modern jurisprudential questions. In many instances it does, but in other instances it doesn't. And that should be cause for reflection. Now, I appreciate as a historian, it's easy for me to pivot. What historians do is they say, okay, that question doesn't really work well for the 18th century, so we ask a different question that is more commensurate with the terms of how people thought. I understand why judges and lawyers can't do that. The reason they're asking these questions is it's at the heart of a litigated case that they have to resolve. But then there should be potentially some humility, some recognition that if there is a mismatch, rather than slamming square pegs into round holes, instead say, perhaps the history, faithfully understood here, can't fully resolve this question, and we have to take seriously that a different tool is needed. Thank you.
Thank you, Jonathan. Rebecca.
Thank you. That was wonderful. Thank you so much to Michael McConnell for inviting me to this great event with so many interesting people giving their thoughts. I just wanted to say to Michael that, like the famous story about the snake, you knew who I was when you took me in. So I hope you will forgive me, and there'll be others of us, but for taking a somewhat contrarian view about the new court's embrace of originalism. And so in that spirit, and also maybe to debunk something Jonathan just said, I'm going to start with a nod to origins, I say, more than originalism, by beginning this way. We, the people of the United States of America, or not of America there, we, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty, to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. It seems to me it would be hard to imagine a clearer rejection of the idea that our national capacities were forever fixed, frozen, maxed out maybe even, at the moment in time when those words, those very aspirational words, were written. But here we are. The court, at least, and some of us here are asking not whether, but how to tinker with the specifics of identifying fixed commitments of a society that we left behind over 200 tumultuous and consequential years ago. So back in 1993, which is exactly 30 years ago now, I was a brand new law professor who was worried about what I saw as a troubling trend on the Supreme Court. Some of its members were showing signs of invoking tradition, not as a way to broaden or deepen our sense of national identity or to further our trajectory toward securing the blessings of liberty, but rather as a constraint on that effort, a barrier. How odd, I thought then, that Justice Harlan's beautiful concept of ordered liberty, the balance that society continually strikes between the rights of the individual and the needs of a changing society, could be distorted so grotesquely so as to describe instead a retrenchment against rights in the name of past commitments. To become, in fact, the mechanical yardstick, in quotes, that Justice Harlan himself had explicitly repudiated. And this was still 4 years before Glucksberg. And so I wrote an article, which I called Tradition and Insight, where I set out to show that insight, by which I mean considered judgment about the meaning of the Constitution, actually echoing a lot of the process that Jonathan described, that insight is impossible without tradition, without considering tradition, but that tradition too often was being dangerously invoked without the benefit of insight. While I've learned a lot in the intervening 30 years, I hope, much of what I said then sets the stage for the views that I want to express today still. My claim here is that tradition properly understood and employed is actually incompatible with originalism, and that the court's efforts to try to use the two in tandem to invoke tradition in the service of originalism, which it has with increasing frequency done, that those efforts are misguided and perhaps even insidious. Tradition is not just something out there to be found, plucked and served up like a ripe blueberry. It is not bare facts or a spreadsheet of past events on a list. Tradition is a combination of practices that together demonstrate over time a common belief system among those who participated in developing those traditions. In order to constitute a tradition, a practice must manifest some kind of societal judgment, a belief that a practice is good and has value. Traditions reflect values. Traditions expose us to the judgments of our predecessors and thus have a didactic element that guides us in making the judgments that will define our own day. Excuse me. Yet, we are a country with as many deplorable traditions as laudable ones. As the cultural historian Gary Wolves put it, running men out of town on a rail is at least as much an American tradition as declaring unalienable rights. So the process of absorbing our traditions is more about figuring out which traditions we will honor and which we will reject than it is about following any rules laid down. The engagement with tradition in an effort to determine meaning is inevitably a hermeneutical endeavor of interpreting and assessing the evidence as part of the project of applying it. The data points here take place over time, definitionally, and thus the effort must be a dynamic one and not a static one. Ultimately, the engagement with tradition, with its inevitable need to reconcile disparate threads and trends, excuse me, is a very human and a non-mechanical exercise in judgment. Tradition is normative. Originalism, by contrast, aspires to be neither dynamic nor normative. Originalism has as a core tenet the idea that the meaning of the Constitution is fixed at the time it is ratified. But traditions are not fixed, and indeed are incoherent as something fixed. Even traditions that existed at the time of the Constitution's origins did not exist in a snapshot. Like the old saying about never stepping into the same river twice, a tradition cannot be trapped at a moment in time and frozen. Its meaning is determined only through judgment in context over time. And yet any such engagement with tradition is in stark tension with originalism's promise of right answers about fixed meaning at one point in history, and especially is in tension with originalism's claims to judicial restraint. Many scholars have noted how particular invocations of tradition by the court have been inappropriate because they were from the wrong time or the wrong level of generality, or they were wrongly understood. Yes, but my point is more categorical. Tradition is essentially inconsistent with originalism. I'll briefly give some examples of the use of tradition in Dobbs and Bruin, just as an illustration of my claim. Dobbs began by stating that, quote, an unbroken tradition of prohibiting abortion on pain of criminal punishment persisted from the earliest days of the common law until 1973, end quote. The number of important judgments concealed in this statement is significant. For example, Justice Alito elided over differences between pre- and post-quickening laws, which is a failure to engage with moral judgments involving the evidence before him. He also judged the absence of affirmative rights in favor of women at a time when women had no political power to be equivalent to valid societal judgments against such rights. He also appears to have considered the practice of treating the killing of a fetus the same, whether or not it was done at the woman's behest or as an injury to her, a validation of her utter irrelevance to the moral question. For a question as complex and societally significant as the right to abortion, the court never acknowledged the moral judgments like these that it was inevitably making all along the way, safely shrouded behind references to societal tradition. Responsible use of tradition entails the critical assessment of the complexities packed inside a tradition. A most vivid complexity here is the foundational choice whether to ratify abhorrent societal traditions or to abandon them. In Bruin, there's also a problem of making many judgments masking many judgments behind tradition. The biggest of these, I suppose, is the court's rejection of the Harlan tradition itself, the tradition of ordered liberty, which takes into account the needs of the community along with the rights of the individual. The wisdom of rejecting that tradition is a question that tradition itself cannot answer. Human judgment must answer that question and justify its answer. But the result of pretending that tradition alone dictates the answer gives us a holding that owning a gun is now the only constitutional right we have that cannot be constrained by interests of public safety. And if you ask why that counterintuitive result is the right one, the answer is tradition. So if I'm right, the tradition is incompatible with originalism, then why does the self-proclaimed originalist court continue to increase its reliance on it? Well, the use of these two incompatible methodologies does at least two salutary things for the court. First, originalism is an answer to those who would say that the court is using tradition in an activist way, only in the service of unrestrained conservative thought. No, they say, we are originalists. We are bound by the original meaning of the Constitution. So that helps give them a defense to the attack that they are activists in an active way seeking their own results. But then on the other hand, tradition, in turn, can soften the concerns of those who worry that originalism itself is too rigidly barren. No, they say. We look to tradition as our evidence of original meaning, and that is a social and human artifact. So the two inconsistent methodologies work in tandem to provide rhetorical cover for a court that is making massive numbers of important moral judgments without ever needing to offer candid justification for them. Indeed, the methodologies are meant, or appear to be meant, I should say, I guess, because it's an intuition perhaps, but that they appear to be meant to suppress or hide the role of insight with their claims to objectivity and restraint. So, sadly, 30 years later, at the other end of my career, I'm still calling for the use of insight, and the call for the use of insight in the understanding of tradition is as poignant as ever. Thank you.
Okay. So I think I agree with many of the things my co-panelists have said, except for the parts about originalism. So I should probably start there. The way I see it, and a lot of this is contained in various articles I've written with my frequent co-author, Steve Sachs, originalism is fundamentally a claim about law, that the official story of our legal system is that it originates at the founding, that's the starting point for our legal system, so that our legal system starts at the founding, but then includes all lawful changes that have been added to the legal system since. So the Constitution is created at the founding, but of course the Constitution changes in obvious ways through Article 5 over time. It changes in less obvious ways through perhaps liquidation, tradition, precedent, things I'll talk about in a second, over time as those are added as well. It's enacted, as Jonathan tells us, in a world of legal assumptions and in a world of unwritten legal rules as well. So those are part of the original legal system. We have to keep an eye on how those change over time as well. But the basic picture is that originalism is fundamentally a claim about law, that our law originates at the founding, and it includes what has lawfully been added to it since. So of course, a lot of originalism then focuses on the text of the Constitution, one of the most important legal instruments that exists at the founding, and that frequently at least structures and constrains, even if it doesn't always end or provide one right answer to our constitutional debates. And we have to look at the text of the constitutional provisions that have been enacted, understand their original meaning, their original legal force in context, to figure out, how much kinds of discretion and how much room for change is given to what kinds of other government actors. Now here I agree with a lot of the things that Jonathan said about the perils of doing this kind of enterprise. Because the Constitution exists as part of the law at the time it's enacted, it's very hard to understand that cold or with modern assumptions, because there are lots of things about founding era law that are not what's taught in law schools in the 21st century. And so it's true that to study the original legal meaning of the Constitution, you have to have a lot of legal context. I also agree more specifically that some people who wave the banner of originalism are too textualist about it. They sort of assume that there's nothing behind the text, that you don't need unwritten legal rules like the kinds of rules of statutory interpretation or construction of ambiguous provisions or reconciling inconsistent provisions and the like to make sense of it. I think the people who proceed under that kind of textualism are being anachronistic, and that's something to be guarded against. It requires more research and more of a lawyer's mind to make sense of the text. I also agree even more specifically that one place this probably comes up and one place that modern doctrine needs a corrective is in understanding things like the original meaning of legal rights. It's true that the idea of that a right just must be a trump, a sort of categorical trump in the modern sense, is not obviously true about the original meaning of rights enacted in the 18th and 19th centuries. Now, they still did have some rights that operated as trumps, right? They still had positive rights and retained natural rights and a sort of complicated category of rights that Judd Campbell and many others have written about. So I don't want to give up too much there until we get into the details, as I'm sure we will over the rest of the panels. But I think it's completely true that it's more complicated, and you need those kinds of distinctions to make sense of the original meaning of the Constitution. That said, I think Jonathan also said something about how legal questions are sort of as hard to understand historically as any other kind of question. That sort of understanding the law of the past is as hard as understanding the intellectual milieu, the social concerns, other things about the past. And I'm not so sure that that's right. Because one of the features of looking at history through law, not just through the lens of intellectual history or social history or moral history or literary history, is that law attempts to distill controversies to abstractions. It attempts to take sort of our messy disagreements, even now, and turn them into operable legal rules. Sometimes it does that more effectively, sometimes it does that less effectively. But the whole point of legal rules is to distill something a little bit more actionable out of the general soup of our politics. And then they're applied to the legal process, which again operates often to strip away context, because we need to strip away context to get the cases decided and to figure out what to do. And so law is often adjudicated in systems of a limited evidentiary record on purpose, or with presumptions about who carries the burden of proof or the burden of going forward, so you know what to do in cases of uncertainty. It's a point Justice Thomas makes in Bruin. I think it's an important point in thinking about how much of this kind of historical and uncertainty and ambiguity do we really have to worry about as constitutional lawyers. I think it's true. We have to know a lot of history to be able to make sense of the text. But I'm not as worried about our inability to do so as perhaps somebody who approaches it from the historical end rather than the legal end does. In a sense, the point of law is to give fake answers to hard questions because we don't know the real answers, right? What should the drug policy be? Who should be in charge of the country? What is the right way to handle climate change? These are things we all debate. And so we have laws on these topics that are not the right answers, but are the answers that we're required to take as a government going forward until somebody comes up with a better answer that convinces enough people to put a new one in place. And I think that kind of mindset is crucial to understanding how the Constitution works the way it does. Okay. Now, what about beyond the text? What about other kinds of law, other kinds of legal rules that operate to answer the question about what happens in the absence of the text? That brings us to liquidation. One of the most important, I think at this point, principles for understanding the meaning of ambiguous texts is what James Madison called a couple of times liquidation. We could also just think of it as precedent from the historical point of view rather than from the modern point of view. The basic idea, as James Madison put it, was that all texts, the Constitution among them, are inherently more or less ambiguous, and to the extent of their ambiguity, they become liquidated over time through a series of more specific adjudications and decisions. Under the assumptions at the time, this meant courts could make those decisions, but not just courts. Anybody who applied the legal instrument could, which is why the practice of the president and Congress and states and many other people could also liquidate the meaning of a constitutional provision. It took multiple decisions to kind of really create a true line of precedent, because they didn't have the modern sense that one decision by one apex court sort of creates an order that we're all required to follow. And you added together this set of decisions and interpretations of the text over time, and that would frequently give more concrete, constraining meaning to an ambiguous text, the same way that a series of judicial decisions construing an ambiguous statute can. And that would sort of fix and help settle the meaning over time. Again, in a way that's natural to us to think about precedent, but maybe less natural if we think about a different institutional milieu for liquidation. Now, I also think it's true that there was another way in which tradition could be relevant, and this is sort of as a form of insight. So you might think of liquidation as tradition as binding authority, tradition as precedent. But traditions that were looser, that didn't contain all these features, as a lot of the things that Sharif discussed are, could still be a form of persuasive authority. When confronting the meaning of a text, understanding all the kinds of context we have to bring to it, the interpretations, or at least the baseline understandings of a lot of people over time, can be a useful persuasive tool. And so it's not a surprise that decision makers like the Supreme Court would frequently cite all sorts of things that they think are informative on the question, even if they don't rise to the level of liquidation, or sort of tradition done in the formal legal style. Now, These things also can run out, and that's where the Constitution structure comes in, that frequently what the Constitution does is then allocate decisions to various departments of government, whether the Congress or the president or things that are left to the states under the 10th Amendment. And so it's right, as several of the panelists have pointed out, that you can't be too aggressive or overzealous about reading tradition to a straitjacket, into taking away the fact that a lot of the time the answer is left up to the government, answerable to we the people, to make decisions of what kinds of laws to enact, and that's right as well. But the key is just to ask sort of those three questions in the right order. You know, what was the law at the founding? What constitutional rules frame our decision? What additional binding precedents or persuasive authorities have we accumulated over time that narrow the range of decision? And then, to the extent we still have a range of options, you know, who is in charge of making this decision? Who's been given the power to make that decision? I think this is all straightforward. I don't even care if we call it originalism. I'm happy to call it originalism. I'm happy to call it something else. But I think it's a commitment to history, first through text, and secondarily through practice. That's the basic structure of our legal system. And I don't think any of that should be controversial. Now, the last point is this actually what the Supreme Court is doing? And fair enough. I don't think I have time on this panel, maybe I'll do it tomorrow, to try to defend at length the Supreme Court's record in every case on every one of these questions. And I don't think it would be plausible to say that the Supreme Court has a perfect batting record on these questions either. But I do think it's actually coming a lot closer to this than people give it credit for, and certainly a lot closer to this than it has in a really long time. So maybe we'll just have to liquidate the specific examples and counterexamples the rest of this panel and questions of the course of the day. But I don't think there are that many examples of the court rejecting this in principle, of the court not seeing that these are the basic steps in the methodology. And if the point is that, you know, the Supreme Court sometimes does things badly, I mean, so do we all. Thanks.
Thanks very much to everybody, and especially for keeping within the time limits. Let me first ask if people on the panel want to respond to anything that other people on the panel have said.
Well,
John?
I'm happy to. The very first question I wrote down as you were making your comments was, do you think the Supreme Court is doing what you were saying is good originalism? Whether we should call it originalism seems to me a very important question. We might describe what you're describing as Bodianism, right?
Even better.
Yeah, we could rally behind that. So I specifically in my remarks talked about what the court was doing, not a lot of my originalist friends who take these questions more seriously, not just you, Will, but many people in this room. I think the court's appreciation for a lot of the things you acknowledge, you mentioned Judd Campbell's work, is not as deep as it ought to be. So I think that's important too. You're in agreement with that. We've had this longstanding friendly disagreement. We can litigate it again or liquidate it, try to, about the Constitution as law at the founding. Because I think that's actually where some of these most interesting disputes are getting played out. As I see it, that very question, what is the Constitution's status as a kind of law, conventional or not? Is it a different kind of law? Is it a law based on popular sovereignty? Is it a people's document, a lawyer's document? Is an essentially contested question at the founding. So even if people recognized a difference, as they surely did, between a constitutional or legal question over here and a policy or political question over here, the boundary between the two could not be settled by existing law or the law of the Constitution. It required a political dispute and settlement, which I would suggest is perhaps broader in character than liquidation is sometimes described. And then how that produces a very different kind of post-ratification history and tradition, perhaps more along the lines of what Rebecca was describing, that isn't structured by a kind of original law that is providing a sort of set of procedures, when the very procedures themselves or their very application to the question seems to me at stake as well. So, I don't know. I think that's relevant to the broader conversation.
You want to weigh on those? Yeah.
Sure, a few things. So I should say at the outset, at the very broadest level, I identify as a Bode-Saxian on original law being the ultimate criterion of constitutional law. And I think that at the other end of the spectrum, in terms of applications, I share Will's sense that the court is doing a much better job on these fronts than it has in a long time. So a lot of my concerns are twofold. One, there's really two questions about the kinds of traditions I was describing. So one is, what's the argument for giving them any weight at all, even if it's the persuasive authority that Will describes? And I say in the piece that I was referring to that I think there is an argument for giving it persuasive authority, even if it didn't, these practices don't reflect the kind of debate that's required for treating them as precedent. And on that first question, I'm mostly agnostic in the piece. I say, here are some arguments for treating it as at least persuasive authority. Some of the cases, so you can think of counter arguments to those arguments, and probably at the end of the day, the way things shake out will vary from clause to clause. The main kind of critical or probing I do on that first question is just to say, you know, it would be nice to see more about why these kinds of moves are legitimate where they are. And sometimes the court is assuming that they're all blessed by Madison, they're all covered by Madison's blessing of liquidation, when I don't think all of them are. That's partly a kind of housekeeping, intellectual housekeeping point. The second question is, assuming that it's legitimate to rely on them, or once we have relied on them rightly or not, what follows about how we should treat the precedent that depended on them? And that's the part where I take a more determinate stance and say, I think all of the arguments I can think of for relying on these traditions, if the traditions aren't just icing on the cake in the analysis or an argument in the alternative, which in some cases they are, I think, if they're really doing work, they're bearing load in the constitutional argument, then I think there's a very strong case for saying when the traditions have changed, to whatever degree they had to take hold to be judicialized in the first place, when they've changed to that same degree, then there's a very strong argument, maybe a conclusive argument, for updating the precedent in keeping with them. And that the reason I found that striking, and maybe it's not striking, maybe I shouldn't have found it striking, is that it feels against the kind of originalist instinct. So the go-to opinion I have in mind here is Justice Scalia's opinion in Roper, where, of course, the court said it's unconstitutional, it's a violation of the Eighth Amendment to execute juvenile offenders. And it's overturning a precedent that's only 15 years old. But it's doing it on the basis of changes in practice, what it identifies as changes in practice. And Justice Scalia first quibbles with the claim that there have been sufficient changes in practice. The second thing he says is, it's ridiculous that the court is not saying we got it wrong, we got the original meaning of the Constitution wrong 15 years ago. It's saying that the Constitution has changed in the last 15 years. And there, I think, you see the reflection of the kind of instinct, what I've been describing as a kind of originalist instinct, which is to think that if the original meaning of the text is fixed at ratification, then the norms created by that meaning are also fixed at ratification, that they can't themselves be something that changes over time. Now, there's no logical connection between them. You can think that the meaning that was fixed makes changing precedents, changing practices relevant to the effect of that meaning over time. And actually, in a Fourth Amendment case, Scalia says something very much like that. So it's really just to kind of basically force the question of exactly what justifies relying on these in the first place to the extent that we do, and then also force the question of what the implications of relying on them are, at least where they are a hinge point of the decision and not just window dressing.
Rebecca, did you want to weigh in on this dispute or any other?
No.
No.
I'm good,
Okay.
thank you.
Let's go to all the learned people in our audience and see what they have to say and questions that they want to ask. Yes, sir.
So this is a marvelous letter, if nobody has seen it. It's a What's that? Okay. So the question is about a recent invocation of history by Chief Justice John Roberts, who was asked to testify asked to come to the Senate Judiciary Committee and testify about the Supreme Court's ethics and code of conduct, and wrote a letter citing various, facts about tradition about why he wasn't going to come testify. And this is a marvelous letter just because it's a marvelous piece of lawyering. So I highly recommend it to anybody who hasn't read it before. Because the letter explains that, it's happened extremely rarely, and only twice in the history of our country has a Chief Justice come to testify before a Senate committee on a non-appropriations matter, which is what he's been asked to do. But of course, a lot is packed into defining the question in that way. Why a Chief Justice rather than another justice, to avoid the fact that Scalia and Breyer went for the Senate, 10 years earlier to talk about all sorts of things. Why not appropriations, et cetera, et cetera. So it is an illustration of the fact that framing the question correctly is certainly important to doing it right, but also, if you're trying to be a good lawyer, an important way to get the answer you want to get out of that question. Now, I just want to note, this was like a voluntary request to appear, so there are weightier constitutional questions that may well arise. If the Senate were to try to send a coercive subpoena to the Chief Justice of the United States, it would have a replay of some of the issues the Supreme Court itself recently resolved in respect to President Trump. And there are sort of real constitutional questions there I don't mean to make fun of, but it's an excellent incident.
Other question? Oh, you have a microphone, good.
Well, I want to ask about the concept of liquidation, because one could imagine in a certain context, a certain liquidation makes sense. But that begs the question of what is the contingency under which that liquidation continues to make sense? At what point do we say that the conditions that we are now living within no longer make the liquidation the actual liquidation sensible anymore, and how do we evaluate that change to know whether we're entitled to have a new settlement or a new liquidation?
I want to take this opportunity to engage in self-promotion. I have an article on this published in the Stanford Law Review, and I have reprints in my bag that I need to get rid of. So if anybody wants to read more. I think the short answer, at least for Madison, and this is actually a tricky thing, is that Madison sort of thought about and talked about liquidation much more carefully than many people did. But you never know with Madison whether we're getting, is this the sort of the widespread concept of liquidation, or is this the genius of James Madison? But I like the genius of James Madison, so I'll let him answer. I think the right answer to the question is by analogy to precedent in two respects. So every case has a holding, and then subsequent cases give rise to the question of how broadly should we understand that holding, right? When the court held that only inherently dangerous devices could give rise to third-party liability. What were the assumptions that gave rise to that, and when do we declare the abolition of privity or whatever? And I mean, that's a very hard question, and we spend weeks on it in the one-on class I teach, but it's basically the same question as the good news. So a lot of the same tools about just sort of how broadly or narrowly do you understand the nature of the settlement, and what are the essential preconditions come in at the liquidation level. And similarly, the overruling question. Since liquidation is sort of a form of precedent, I'm with Sharif in thinking that at some point, practice can overrule practice. It could be sort of complicated how you get there, and sometimes that takes a sort of a transformational figure to make that happen. But I do think it can happen. But I think the right place to look for analogies to both questions is from the same ways you wrestle with those things in the precedent context.
Thanks for this really engaging discussion. Will, my question builds on this and also relates to what Sharif was talking about of precedent-changing precedent. But at the time we had sort of this idea of liquidation developing, there was also a pretty different idea of how stare decisis worked. It was a much gentler principle where precedent had a little more than its persuasive authority, as opposed to now where it's sort of treated like a one-way ratchet where suddenly things are locked in time and very difficult to undo that. And so how does that change how we should think about liquidation? If liquidation is meant to be a type of precedent, but now our notions of precedent no longer really reflect originally what they did, how do we square that with the type of role of precedent that was incorporated in Article 3 and the tension that a lot of people have recognized between precedent, as it will increasingly sort of load up meaning that departs from whatever the original meaning was in the Constitution, and how the much stricter view we have of stare decisis, I think, can make that tension more acute now than it was at the founding.
So I think this is completely true, right? That liquidation assumes a very different model of precedent and judicial supremacy. And in that sense, invoking liquidation is much more radical than it might seem. To really make that make sense and be part of our constitutional system probably involves ratcheting back our assumptions about judicial supremacy. It definitely involves ratcheting back our assumptions about sort of single-shot stare decisis, where, you know, the Supreme Court decides a case and then they just tell us to get over it, and then, you know, there's no more questioning whether that decision is right or wrong. I think that's actually part and parcel of the assumptions that give us something like liquidation. Obviously, the Supreme Court has not done that yet, although maybe they will.
Can I quickly speak to that? Because I think it builds on some things we've been talking about how we liquidate liquidation.
Yeah.
Because there's a narrower and broader way of thinking about it. There's, of course, the very important question of how representative is Madison of other people at the founding, but if we just take Madison, I think part of the reason he was drawn to liquidation is because he was very suspicious for most of his life of the idea that any one branch, certainly the federal judiciary, could be the final arbiter, partly on Republican grounds that didn't make sense to him that they would be the adequate spokesman for the people, but also on prudential grounds that they wouldn't have the adequate force to settle anything with much authority. I mean, so when he talked about liquidation, it was often a way, I think, for him to activate his broader vision of how constitutional politics would settle the sorts of questions that were not ordinary cases and controversies arising under Article 3, but were instead these foundational questions that really raised disputes about the constitutional system and structure itself that could only be settled by the people themselves. And he had all sorts of arguments for why Jefferson's radical ways of appealing to the people themselves certainly didn't work, but he didn't want to go to the other extreme that a lot of Federalists were beginning to describe, that you would give it to the judiciary. So there's a way of thinking about liquidation that is more jurisprudential in character, like precedent, more on the model of a judge reading a text, and there's a way of thinking of liquidation that is more in the nature of how a politician would go about business and thinking about constitutional politics. And there's a kind of fluidity and dynamism that's baked into that second concept, which leads, again, moving forward from 1789 to wherever in a different way than one that's more judicial in character. And at least as I understand, I think sometimes, Will, you kind of emphasize both aspects, but maybe it needs to be really one or the other, because so much hinges in some ways. If liquidation is part of our law, it seems they go down very different roads to me.
You know, people did this to Madison too. They would constantly tell him, you know, oh, you're a strict constructionist because you're not willing to accept, you know, the loose federal, and then he would say, no, I'm not a strict constructionist. And they would say, you know, so you're one of these, you know, loose federal non-textuals. He said, no, I just think we should read this like lawyers in the ordinary middle way. And I guess I similarly think of liquidation as kind of popular constitutionalism for lawyers.
Michael?
I have a question for Rebecca, which is, what is insight, and how would you distinguish it, or would you, from the judge's sort of ideological predilections?
I mean, obviously, that's a great question. You know, I mean, this is such a big question, and so many people have talked about it that I'm trying to think offhand how to respond to it here just briefly. I mean, the idea, of course, is to use available sources, a lot of the kinds of things Jonathan talked about, because I don't think tradition and history are the same thing, but they are clearly related, and a way to understand traditions would be to look at the historical context in which they arose and what they meant. Certainly, I don't know what to say about the ideological. I mean, you know, all judges are accused of that, right? And so it's a little hard to say just don't do that, right? Don't just engage in outcome-oriented ideological quests for historical meaning. That of course, you can't necessarily prevent people from doing that. But I do think that there are objective ways for judges to go about understanding traditions and coming to grips with the questions that are unanswered, like those little examples I gave in my talk from Alito's opinion. The judge ought to be engaging in what the meaning is, and I think they ought to be making discernments between practices that have, well, looking more in a more detailed way about practices. For example, to just say, well, we don't find any affirmative expressions of rights of this type to abortion, for example, at a time, you know, one might think that should require some critical thinking. And actually, Justice Blackmun did some of that critical thinking when he wrote Roe v. Wade, right? He looked at the history. You can talk about whether he did it wrong. Some people think he did, but what he did do was sort of make judgments about the historical examples that he found, when abortion was outlawed, when it wasn't, and why he thought it might have been or not been. He looked deeper, rather than just checking off a sort of historical practice, to try to see what the meaning of that ought to be when the quest is some sort of societal commitment, right? Because you have to think about what you're looking for. And if you're looking for a societal commitment to a right in a population like women who had no political rights whatsoever, there has to be something more than just looking to see whether there had been a formal expression of a right to abortion. That's just an example. You would have to just sort of look at the context. I think it's basically what judges have been doing. It's the kind of thing that Sharif is talking about in his living traditions. One looks at developments, one tries to assess them, but one doesn't just accept them openly. And I don't like them to be just window dressing either at the end, of course, and that's something that we do see judges do, and judges aren't, on both traditionalists and non-traditionalists make mistakes like that, but I mean, I think it's certainly at least intelligible to talk about the quest for understanding to what extent a traditional practice does or does not reflect a societal judgment that one is looking for. And then the second step with that is to decide, as I say, whether it's a tradition or a judgment that we want to accept today. So I know the assumption of the question is that it devolves into ideological, whatever the word is, just indulging in one's own preferences. But I just believe that is not inevitable. I think law can be objective, and I think the analysis of tradition can be done within the confines of law. So.
I wanted to ask Jonathan a question, which is a kind of an unfair question, because Jonathan is not a judge, but a historian. But I wanted to ask Jonathan what the implications of his analysis are for judging. I mean, let's accept that the Constitution was written in a political language, in the context of a political language, is very different from our own, with many assumptions that differ in very fundamental respects from our own. What does that mean for judges? Does it mean that what they were talking about is more or less unrecapturable, or, as Larry Lessig would say, untranslatable into modern categories? Does it mean that judges should simply give up the attempt at historical reconstruction because they're going to botch it, no matter how earnestly they try it, how well advised by historians' Amici briefs, and instead engage in kind of what you might call general welfare analysis of the virtues and vices of encoding a particular political proposition in constitutional law. What, as the Soviet commissars used to ask, what is to be done?
I would first have them read Bob Gordon, Critical Legal Histories, while I was figuring out the answer to the question.
Perfect.
No, so this is a very important question. And I tried to allude to it at the end because I don't think it's straightforward. So first of all, the notion that, the sort of notion of historicism that I was trying to defend should be differentiated from the idea that received enormous support in many circles of the academy in the post-war period, which effectively denied the proposition of intellectual commensurability across time. So I'm not defending that, the sort of inscrutability of reference or the impossibility of translation point. I'm instead making the more modest claim, which has been, I think is just basic to most intellectual historians of, even if it's doable, it can be a whole lot harder than you tend to think. And the reasons for doing so are contingent. It's not just a matter of, oh, that was sometime in the past and they thought differently. It's that certain things might be more complex and more different in different sorts of ways than readily appear. I think a few periods is that more the case than the American founding, because it can tend to seem to especially people socialized in this nation as though it's more or less familiar, so it's easier for anachronisms to sneak in, but that doesn't mean you can't figure out more or less what people were up to. It just takes a certain kind of abstraction and willingness to see it. Now, what are judges to do with that? Well, importantly, as I emphasized, there are lots of ways in which things that happened in the 18th century, the ways people talked about what happened in the 18th century, do speak to modern questions. So it's not as though it's a one-size-fits-all. So there are certain instances in which I think the history is more or less directly applicable, and you need to do it well or think about the issues it raises and get it right. But there are lots of other ones where it runs more orthogonal. And then you can do one of two things, I think. You can either abstract through the analogical thinking to such a level that you're really not talking about the past and what people laid down anymore, and you need to take seriously what that amounts to, whether or not that isn't, in fact, no different than a kind of general welfare reasoning. And if it's not, you should explain why. But that only starts with a recognition of it being different, rather than, as is often the case, well, a right is a right is a right. This is what it means to have a right. This is what it's always meant to have a right. And therefore, must be the content of this right, because it's, it fits into these sort of particular sorts of categories. Or the Constitution it falls out of the Constitution in a particular way of litigating the scope of the national government's powers, at least recognizing, well, there was once a different group of people, if we're interested in the history, who might have not just had a different answer to that question, but framed the question itself differently. And then that's at least a starting point. So if history is going to be used as a way of trumping other kinds of things in the constitutional system, as has become common, and lots of different people think about it in lots of different ways, but that is using history with a particular kind of authority, I think that carries with it then a need to justify that it is meeting that criteria that you yourself have set. And if it's not, then that means that you no longer get to make the arguments about why it gets to trump the other things. You have to come up with different kinds of arguments. So that's how I see it.
Can I ask a follow-up? So in light of what you asked earlier, why isn't the answer something like, sure, you can do this, you just got to bring a worldview to it. Like at the founding, there's some like pre-legal, you're a federalist, or you're a states' rights, you're a local social compact person, or whatever. But once you have your pre-theoretical worldview, then you can kind of read the Constitution in a normal way. And so maybe now we'd say, you just got to just bring to the Constitution being a conservative originalist or being a liberal living constitutionalist. But once you've got that, and I guess the judges mostly do these days, then you can kind of do it in the normal way.
Yeah, so Joe the Plowman reads the Constitution is replaced by Melanchthon Smith reads the Constitution or Samuel Alito reads the Constitution, doesn't that defeat the very premise that you yourself were laying out about it being something different than that?
Yeah, I mean, it's not my view. I'm
Yeah.
just surprised that might be yours.
Yeah.
Chuck Rakoff.
Speaking for Madison, as is my mind.
Yeah, I'm in trouble now.
I think Madison certainly has a notion of liquidation as a process that's going to have to take place. That's different from saying he has a method or a rubric for describing what it's actually going to entail. So that's kind of point number one. But the second point I want to make is to pick up on Jonathan's remarks and representing the academic historians here as opposed to everybody else. It does seem to me that there's a kind of systematic weakness on the legal side, whether it comes from the professoriate or the jurors themselves, in terms of thinking conceptually in the way that historians from my generation, and I suppose the half generation before me, we're taught to do. I mean, kind of building on Ed Morrigan and my mentor, Bud Balin, is this kind of a rich discussion of how would one unpack, speaking broadly, the political theory and the constitutional implications of the founding era. And I just think I spent a lot of time reading what lawyers do here. That way of thinking conceptually, which of course is also a way of thinking historically, is something that lawyers, for all their eclectic talents, which I'm often very much impressed by, don't really know. I mean, I think it's one thing to think about history. It's another thing to think historically. To think historically means you have to spend a lot of time weighing and measuring and testing the validity and, let's say, the probative value, the evidentiary value of different kinds of sources. I mean, that's what we're trained to do ab initio. And there's no one method of doing it that's really independent of the problem you work on. That's why it's hard to teach history as a science. Because it's not that there's some set of rules that, I mean, it's not like, taking CS 105 or whatever at Stanford. I mean, it's not that there's some, that there's some set of procedures that can be taught that are independent of the problems that you're trying to work with. And your findings are going to be derivative from the sources that are available to you. And of course, they're going to vary enormously and substantially from period to period, country to country, problem to problem. Now, in the constitutional sense, I just want to make one more comment here. On the Madison front, I don't think Madison had a doctrine. I mean, I have to read all your stuff, so obviously, but a lot of stuff I'm behind. I'll try to catch up. I don't think he had a doctrine of liquidation. I think he had a conception, using this in Dworkinian terms, of liquidation. I don't think he had a doctrine of how it would work. But I will say at least this, and it comes back to a point that Jonathan made. I think on federalism issues, Madison felt that the real challenge, it has matured in the 20 years of his retirement from 1817 to 1836. I think Madison had a sense that the federal system was becoming increasingly stressed for a whole variety of reasons. It begins with Missouri, and it culminates, I think, with the nullification crisis, which takes place, 3 years or so, 3-4 years before his death. I think his position there was it's not a method, but it is a perspective. Madison liked to describe the federal system as a real nondescript. Of course, nondescript in the 19th century had a very different meaning from what it has today. Nondescript simply means it hasn't been described. It's nondescript. It hasn't been described. If we say somebody's nondescript, we say some kind of schlepper, or whatever. Nondescript means it hasn't been described, and therefore, to understand it, we have to deal with it in its complexity, in its nuance. So to make sense of the American Constitution, your first obligation as a commentator or as an interpreter is to immerse yourself in its inherent complexity and try to work your way upwards from that understanding. Now, again, I don't think that's a method. And maybe in some extent, I think it may be historical in nature. I've said this in different places that, a lot of my graduates got annoyed saying, in another age, Madison would have gone to graduate school. but he didn't have the option. But if you went to graduate school, it's a question, would he have been a historian or a political scientist? You know, he read a lot of law, as Mary Builder notes, but he never wanted to practice it, so you could judge from that, what you will. But then I think there is a Madisonian way of thinking about these problems, and I just don't think, to be honest, I don't think lawyers are very good at it. But it's, because you have your own kind of training, which is very impressive in some ways and very deficient in others. And so I haven't asked the question, but I made a comment, but I think I try to build upon all the great things that Jonathan was saying, and to differentiate his approach and mine from what the rest of you guys are trying to do.
Yeah, Andy Koppelman, Northwestern. Will, you said that one of the attractions of law is that we bound problems. That the point of law is to give fake answers to hard questions, but there's a definite answer. This is the value of publicity. Everybody can tell what it is. That's already in some tension with the originalist project, which is that we're going to go back in the archives and find out that what we've been thinking about the meaning of a given provision turns out, after we do all the corpus linguistics analysis, to be wrong, so then we revise it again. But the way in which that plugs into the history and tradition thing is, it's one thing if you're trying to figure out the original meaning in context of a given set of words. I take it that the professional historians are going to say, when a graduate student comes to you and says, I'm going to settle this historical controversy once and for all, there will never be controversy about this again after I write my piece, you say, oh, you're young. It just doesn't happen. So there is a tension between the idea of having clear public law that everybody knows and the project of historical inquiry. But I take it one thing that's come out of all of the discussion of tradition is that once we go beyond particular constitutional text to tradition, tradition is capable of being characterized in so many ways by so many different people that at that point, I just want to ask Michael's question again. Isn't this just an opportunity for a judge to look at the history and say, well, I can construct a narrative of the history that allows me to surprise the entire civilization with my new set of rules about administrative law or guns or whatever else I happen to feel strongly about, and say, I'm just enforcing the Constitution. And isn't that in impossible tension with the value of publicity, which is supposed to be one of the virtues of the rule of law?
So, two things. So I don't think anybody other than maybe Jeremy Bentham thought that you could accomplish the kind of publicity and settlement values of the rule of law through kind of codification and written text alone. I mean, it would be nice if that were true, but that's sort of the liquidation challenge. If Madison says that's not going to work out. And that's why you need something else to fill in the gaps. And I do think the attraction of liquidation or traditionalism done well and non-willfully is that it will often not be a big surprise, because it will be drawing on the things that many people understand in their daily lives and practices. Now, it can be manipulated, and sometimes it's complicated because we have traditions that are in tension, or traditions that have some rot at their core, and so that's not perfect. But I do think compared to, let's say, a starker form of non-liquidation inflected originalism, liquidation at least sort of softens it a little bit. Now, the one thing I'll just say on the naivete is I think there is a letter from James Madison when he's talking about what to do with all his notes from the convention, which he's spends a long time working on, and Maribel's written about this, and he has a letter where he says he's going to wait to publish them during his lifetime, but he's going to wait to publish them until all of the major ambiguities in the Constitution have been settled. And he seems to imagine that's going to happen like before he dies. I admire that optimism.
So can I just say a quick word on this? Having cast my doubts on some of the traditionalist cases, all of them, none of them say they're overriding some other more determinate source, clear text or meaning or anything like that. So if that's right, if we assume that we've got a case where that's true, and then the choice is between trying to rely on tradition or some more naked value or policy judgment, I do think there are benefits to relying on the tradition, not just from a kind of formalist perspective, but from the perspective of the critics. So, Rebecca was arguing with Alito's application of traditionalism in Dobbs. I think I have a disagreement on that granular point about whether he's ignoring the pre- and post-quickening distinction and so on, but in a way that just proves the point, that there's more to pick at and take issue with. And if the choice is between refracting these judgments through traditions or not, refracting them through traditions has to have some disciplining force, or else the arguments against Alito's application of traditionalism wouldn't be able to get the foothold that they claim to have.
We have run out of time for this first panel, which I think means this conference is well begun. So we have a bit of a break, and then we'll reconvene for the second panel. Thank you.